Hi there, good morning. Thank you for joining us this morning. It's 9:30, so we are going to go ahead and get started. My name is Erin, and I am the Director of Marketing with HireLevel. Today you have joined our Notes webinar program entitled COVID-19. We will be discussing basically the impact of the Illinois and Missouri workers' compensation with AJ Sheehan and Shelley Wilson. So a few housekeeping things before we begin. All of the attendees are set up in listen-only mode. You do have the ability to ask questions throughout the presentation if you want to type in your question box, and we will be happy to get those answered for you. The call will last close to an hour. So let's get started. A couple introductions for AJ and Shelley here. So Shelley Wilson is a shareholder in the St. Louis office of MVP Law. She has been practicing law for the past 20 years in both Missouri and Illinois. Shelley defends all types of workers' compensation claims, ranging from soft tissue injuries to permanent total disability cases. She has tried and argued cases before the Missouri Division of Workers' Compensation, the Labor and Industrial Relations Commission, the Missouri Court of Appeals, the Illinois Workers' Compensation Commission, and the Illinois Court of Appeals. AJ Sheehan is an associate attorney practicing out of Springfield, Illinois. Since 2015, he has focused his practice on representing employers and insurers and workers' compensation matters throughout Illinois and Missouri. He also works with insurers to protect their interest in Missouri medical fee disputes. Mr. Sheehan handles a wide range of issues, including complex cases involving permanent total disability, wage differential claims, and Medicare set-aside trust, to less complicated cases involving settlement negotiations and pro se settlements. He is currently working out of the firm's new Springfield, Illinois location, where he specializes in Illinois-specific issues facing employers and insurers in the workers' compensation arena. Thank you both for joining us today. I turn it over to you.
Hello, everyone. Thank you so much for calling in this morning. We appreciate it. These are certainly strange times that we're living in and trying to navigate. Erin and I were talking before everyone else joined us that you learn something new every day, and we're going to get through it the best we can. And hopefully we can provide you with some guidance about the state of the law and some new developments in Missouri and Illinois today that can help you navigate these waters successfully. I also wanted to mention before I got into my materials that please feel free to visit our website at any time. That's mvplaw.com. We are a regional Midwestern law firm, and we have attorneys that are able to help you in Kansas, Missouri, Nebraska, Oklahoma, Iowa, and Illinois. All of our attorneys are listed on our website, and you can find out where they practice. So if you need help in Iowa, you can get on there and see who could help you in Iowa. Our contact information is all there. You can email or call any of us at any time. Whether we have your case or not, we're always happy to help. So please reference that. Also, our website is a good resource because we are constantly updating that site with any new developments that come down in all of our jurisdictions regarding COVID. So if emergency orders come out, that will be reflected on our website. Docket information and changes in the dockets due to COVID will be found there. So it's just a really good resource for all of you, and I encourage you to visit it if you need any help or any guidance at all. Now, I'm going to talk to you this morning about Missouri. AJ is going to handle Illinois. If you have questions, let us know. We're happy to answer them, obviously. But I'm going to talk to you first about the general state of the law in Missouri. So, generally speaking, a regular disease that the general public is exposed to is not covered under workers' compensation occupational diseases. This would include influenza or colds, and that's even if the employee is a healthcare worker. The reason behind that is that those kinds of diseases can be contracted in many different places, not necessarily just at the employee's place of employment. That being said, however, if an employee catches a more serious disease, and that disease is one that could easily be identified as coming from their place of employment and not endless other sources, then that person could be eligible for workers' compensation benefits in Missouri under the occupational disease category. And we feel that workers' compensation cases involving coronavirus will likely have that possibility of being compensable if the employee is in the healthcare or first responder field and they have been specifically exposed to the virus. So, directing your attention specifically to the section of the law in Missouri that deals with this, that would be section 287.067. And according to that section of the Missouri Workers' Compensation Act, occupational diseases are defined as an identifiable disease arising with or without human fault out of and in the course of employment. So ordinary diseases of life to which the general public is exposed outside of the employment, those are not going to be compensable, except where those diseases follow as an incident of an occupational disease. The law goes on to state that the disease doesn't have to be foreseen or expected, but after its contraction, it must appear to have had its origin in a risk specifically connected with the employment and to have flowed from that source as a rational consequence. That portion of the Act goes on to provide that any employee who is exposed to and contracts any contagious or communicable disease arising out of and in the course of his or her employment shall be eligible for benefits under the occupational disease section of the Act. So what does this mean? Practically speaking, the occupational disease portion of the Act in Missouri would certainly include coronavirus exposure. Your key inquiry or the question that you ask yourself is going to be whether this employee's job duties increase their risk of contracting the disease. So with that in mind, it's pretty clear to us that people working in the healthcare field or first responders could make pretty decent arguments that exposure to and subsequent development of coronavirus is a compensable work-related disease. And this would especially be so if they're in situations where they are treating patients with the coronavirus diagnosis. So this is going to hold especially true for your employees that are working in nursing homes or skilled residential facilities, any type of medical facilities for that matter. Now, the majority of employees obviously don't work in that kind of environment, and so what about them? On the other hand, if someone's just working at a factory or any other type of job where they may be around a lot of people and therefore they might have increased exposure to contracting coronavirus, those cases will not likely be compensable because exposure for those types of employees arguably would be considered an ordinary disease of life to which the general public is exposed. And I think this argument or defense is likely going to get stronger, unfortunately, as coronavirus becomes more widespread in the general population and in the general community. Obviously, if that happens, then any person, regardless of their employment, is at an increased risk of contracting the coronavirus. So it will be harder for that person to prove that their job alone put them at an increased risk when it's so widespread within the community. Now, you should know that on April 7, Governor Parson did put into place an emergency order to specifically deal with first responders and exposure to coronavirus. So that order, in that order, the governor directed the Division of Labor and Industrial Relations in Missouri to implement an emergency rule, creating a presumption that if a first responder contracts COVID, then we're going to assume they became infected in the line of duty. That's going to be the presumption built into the law right now. Now, that being said, that's not the end of the analysis. The presumption is rebuttable, and if an employer can prove that the first responder's exposure was not in the line of duty, then we're able to defend or hopefully deny the claim. So that's kind of where the law stands right now on coronavirus. We haven't had any additional emergency orders come from Governor Parson, specifically changing the law or modifying the law since April 7th. So that's the most recent state of affairs. Now, the other thing I think that you have to consider as employers in Missouri is not only potential COVID claims that your employees might file, but what is the impact of all of this on your existing claims? So presumably you have claims for back strains and rotator cuff tears and carpal tunnel releases that were progressing in the system before this all blew up on us. And what happens to those claims now that all of this is going on? There's what we're finding an impact on those individuals' medical treatment and the timeline of that treatment. And with that impact can come impact on their time off work and their lost wage benefits and how quickly you're able to close their claim or resolve it. So what we're seeing is a lot of medical clinics and offices, physicians' offices, putting protocols in place to help prevent the spread of COVID-19. And those protocols are having an impact on your existing claims. Medical providers have begun screening patients. We're seeing postponing non-emergent office visits and procedures. We're seeing some clinics asking patients if they've traveled to high-risk areas in the past month or so and whether they might be exhibiting symptoms consistent with COVID. And as you probably notice every day, it seems that we're getting another update from the CDC about the symptom list, and they're adding to it. If the claimants are answering yes to any of these questions, then the doctor's offices may be requiring them to postpone a routine office visit or put off a surgical procedure that can wait. As this continues to evolve, we may see some additional protocols be implemented by our treating physician, and those could result in additional delays in medical treatment and non-emergent workers' compensation situations. As you know, we, as employers and insurers, as well as the injured workers, rely on these medical visits for information on the status of treatment, on how the person's progressing, whether they need physical therapy, whether they need more physical therapy, what their work status is, and whether they require restrictions or they can get back to work in a full duty capacity. We rely on these follow-up appointments with the doctors for all of that information. And so when those appointments are delayed, it can have an impact on our claims. What I'm seeing in my cases is that if I've got an IME scheduled at this particular time, and an IME is an independent medical evaluation. So that's something where I've selected a doctor on our behalf to take a look at a case and just kind of tell me what they think. Those typically are being rescheduled. Those are not going forward at this time based on what I'm seeing. And I'm seeing those be rescheduled for end of May, June, but I'm not seeing those go forward, and that's likely because they're completely elective. As for our surgeries, I'm also seeing those being postponed. I have one case right now where the injured employee was supposed to have a rotator cuff repair, and that has been indefinitely postponed. We don't even have a rescheduled date on it yet. So I think probably most elective surgeries are being delayed. Now, for follow-up appointments where an individual say they've already had surgery and they're in the stage of treatment where they're following up on a regular basis with the treating physician, those kind of appointments I'm seeing being handled in a variety of different ways, and I think it probably depends on the doctor's preference. Some of them are going forward as normal. I'm assuming that if the doctor feels comfortable and the injured employee feels comfortable, they're agreeing to just go forward with the proper precautions in place. I'm seeing some of those appointments be rescheduled, and probably the most creative and unique approach I'm seeing are telemedicine visits coming up for those follow-up appointments. So I'm seeing some physicians that are conducting teleconferences with the injured employees to check in with them about their current complaints and where they are with their therapy and whether that's benefiting them. And then the doctor's issuing a report based on that telemedicine visit. And that is, if the case is in a certain point of a medical treatment where that's appropriate, I think that's a great idea to keep treatment progressing without unnecessary delay, despite what's going on in the world right now. Now, as you can imagine, if medical appointments of your injured workers are delayed, that might result in their return to work being delayed, whether that's in a light duty or a full duty capacity. So if they were supposed to follow up on April 3rd and now that's been kicked to May 3rd and they're remaining off work all that time when maybe they would have gotten a release at that April 3rd visit, this is going to prolong their lost wage benefits. Although I have not had the issue specifically come up on any of my cases, my thought is that in Missouri, the administrative law judges are going to view this fairly liberally. That meaning that if the rescheduled appointment is at the request of the authorized treating physician and the delay is a reasonable delay that's attributable solely to the COVID situation, I think the judges are going to not want to penalize the injured employee in any way as it pertains to their lost wage benefits and would expect us to continue those for a reasonable period of time. Now, I think there are creative solutions to this. So if that delay becomes a little more than you're comfortable with and you think, listen, this person could be getting back to light duty work or this person was set for a full duty release, I think that's when maybe you consult with your claims representative or your defense counsel about some creative solutions to maybe get that work status that you're looking for. And one of those, I think, is one that I've already discussed, and that's the telemedicine appointment with the doctor. Maybe see if the doctors are willing to, be a little creative in how they see the injured employee for follow-up to maybe get that work status that you were expecting to receive earlier. The other thing that I thought you all would likely be interested in is the impact of the COVID situation on our dockets. So as you know, when your cases become litigated with an attorney on one or both sides of them, they get into the workers' compensation system and they're set on the docket by the Division of Workers' Compensation. And there's a variety of docket settings. If your injured employee doesn't have an attorney, they typically, are on a settlement conference docket. Then for your injured employees that are represented by counsel, those cases can go on a variety of dockets at the division, ranging from a pre-hearing to a mediation to a trial. The division in Missouri started canceling settings, in-person settings in March. About mid-March, those cancellations started to come in. And at that point, all in-person appearances were stopped. Now, since that time, they've kind of been adjusting. I've been able to conduct very many pro se settlement conferences, and those are individuals, your workers that have not gotten an attorney. I have been able to do many of those conferences since this all began with the judge and the injured employee via telephone conference. And I simply contact the injured worker, go over all the rights and benefits and the settlement terms, and then we conference the judge on And the judge will ask the questions that they typically ask, were you coerced? Do you feel this settlement is fair? Do you want to accept it? And as long as the injured employee is on board, the judge says, okay, I'll execute the documents and I'll send them back to you, and you're able to get the case resolved that way. That has been a huge benefit that the division has been offering, because, a lot of times the injured employee is ready to get the case resolved. We're ready to get the case resolved. Maybe they need money, especially now. And it's a way that we can get the case resolved, get their case settled, and move along, close the file down, and not have to wait to get through these delays that are coming from COVID. Another thing that's being offered by some of the judges at the division are telephonic settings. I have some judges that are allowing us to do pre-hearing conferences with all attorneys involved by phone conference. I've also done some mediations with the judge and all attorneys involved. Some are by telephone conference. I've done some via Zoom. But these are all really good options for us to keep cases moving despite the in-person cancellation. And ultimately, that has been my firm's goal through all of this. We want to keep advancing the cases through the system despite this situation. And I think we've been successful in doing that. You just have to get a little creative. I've also noted in my own practice that a lot of injured employees are at a place where they want to resolve their claims and they want to resolve them now. I think that comes from the uncertainty of the economy. And so we're able to move some cases a little quicker than maybe we would have if this had not happened, and for a little less money. So those are all advantages if you can find them in this situation. I have started to receive some setting notices from the division for early June. I tend to think they're being a little optimistic in that, and I don't know if we will be back to in-person appearances in court at that time. If anyone's ever been to the Division of Workers' Compensation in St. Louis, that office is a very busy office, and I just don't know if they will want that many people in such a small space as early June. So these cancellations or postponements with the docket could continue even throughout the summer, but we are able to adjust and get your cases moving through the system despite that. I think, one more thing I wanted to tell you about. Any documents that are associated with your cases that need to be filed, whether they're subpoenas that require judge approval or settlement documents, anything requiring a judge's signature. We've also had a lot of success during this period of time getting those documents approved in a very quick fashion. The division has set up an email system for us, so we can just submit those documents via email. The docket clerk sees that they get distributed to an administrative law judge for execution, and then they get emailed, back to us. So that's another way that we're able to just keep pushing through this and not have a lot of delay for your cases. I think that that's really all I wanted to cover under Missouri. I will turn it back over to Erin now so that she can decide if she wants to do questions or go right to AJ.
All right, thank you, Shelley. If you do have questions, now is definitely the time. You can type in the question box of your toolbar, so feel free to do that. We'll give everybody a minute or two to get their questions in if you have any, and then we'll jump to Illinois.
Perfect.
All right, AJ, I don't see any questions coming in. If you want to just jump ahead, and
Okay.
then if anything come up, I will let you know.
Yeah, no, that sounds great. And feel free, as I'm talking as well, even if, I'm going to be focusing on Illinois, obviously, but even if you have questions that you think of as I'm going through my presentation, even if they're related to Missouri, feel free to obviously put those in the chat section so that we can answer any questions or concerns you might have. I will kind of piggyback off of what Shelley discussed earlier. A lot of what is going on in Illinois right now is kind of mirroring what it is in Missouri, but there are a few important distinctions I'll get to a little bit later, that one being the governor's emergency order. It has definitely, it's definitely different in Illinois rather than Missouri at this point. So generally speaking, first and foremost, we'll get to the compensability standard for work injuries in Illinois, specifically to COVID-19. So generally speaking, a disease such as COVID-19, the flu, common cold, things like that Shelley was talking about, contracted at work are typically found not compensable, because those types of diseases and illnesses can be found in everyday life, non-employment life, things like that. So those are typically difficult to find as compensable by the Illinois Work Comp Commission and the arbitrators. Specifically, this compensability standard is found in Section 1D, as in dog, of the Illinois Work Comp Act. Occupational diseases, those are defined as arising out of and in the course of employment that has become aggravated or rendered disabling as a result of the exposure of the employment. So basically, the aggravation or the illness has to arise out of a risk peculiar to that employment, or has to be increased by the employment and not common to the general public. So that's what I was talking about with, your typical illnesses, your seasonal flus, things like that. Even if somebody at work has the flu and they get sick, and you get sick from them, that's tough to prove because obviously people outside of work also have the flu, and you can be exposed to that as well. So the statute goes on to provide the causation standard, which states that a disease will be deemed to arise out of employment if there's a causal connection between the conditions under which the work is performed and the occupational disease. The disease need not to be foreseen or expected, but it must have its origin or risk connected with employment and to have flowed from employment, essentially. So the thing I would point out is that the statute specifically says that the exposure can be for, quote, any length of time, however short. So you can work at a place for one day and potentially, be succumbed to an occupational disease under the Workers' Compensation Act. So in general, for an employee to prove specifically that they contracted COVID-19 at work and that it's compensable there, they have to prove two things. First and foremost, they have to prove that they were exposed to COVID-19 at work, and that they got it at work rather than their non-employment life. And then they also have to prove that they are at a greater risk of contracting COVID-19 at work than in their non-employment life. So what does this mean? It means that contracting COVID-19 at work could certainly be a compensable injury. It's very possible. Previously, before the COVID-19 pandemic came to light, the situations of influenza and the common cold, those are really tough burdens to overcome because the employee has to prove those two things I talked about, that they contracted the illness at work and that they also had a greater risk of contracting the illness at work rather than their non-employment life. So that was a difficult burden to overcome. So cases in Illinois have held pretty consistently that, influenza, the common cold, those are not typically proven to be work-related. But on the flip side, there are certain situations where a healthcare worker contracts hepatitis from being pricked by a needle at work in like the healthcare field. So in those situations, you can pretty easily pinpoint that, yes, it was that needle at work while I was working. I obviously wouldn't have been exposed to that type of risk in my non-employment life. Therefore, it is compensable. So it also means, as Shelley kind of talked about and went into good detail about, individuals currently working in the healthcare field and other work environments where employees will undoubtedly be exposed to COVID-19 at a greater degree than in their non-employment life. Those types of employees will have an easier time meeting the burden. So something I wanted to kind of point out, we're talking about the COVID-19 pandemic, and, basically, work injuries, you have a rotator cuff tear or an ACL tear, things like that, they're going to be potentially out of work for an extended period of time, especially if light duty isn't being able to be offered. But in these types of situations with COVID-19, typically you're looking at things that are, it's a medical only claim where you're just paying for the medical treatment because they have to be home from work, while recovering from a fever and some of the minor symptoms. Obviously, that's different if it's, if the person passes from COVID-19 or something like that. But, typically you're looking at maybe 2 to 3 weeks of TTD benefits that you have to pay while they're off work, or, required to stay at home because they've been exposed, to self-quarantine, things like that. But these are typically not that exposure-wise, not that great. So that is obviously something to think about. So I wanted to talk now about the emergency order from Governor Pritzker. This is one that's been in the news a lot lately. So as Shelley said, the Missouri emergency order from Governor Parson was on April 7th of 2020. So Governor Pritzker here in Illinois went ahead and entered an emergency order on April 14th. Basically, he engaged the Illinois Work Comp Commission to adopt an emergency rule that flipped that burden of proof that I was just telling you guys about, where the employee would have to prove that they contracted it at work and that they didn't, or that they were exposed to a greater risk at work. He basically flipped the burden, the commission did, to say that as long as you are a first responder or a frontline worker in one of those essential jobs, that it created a rebuttable presumption that they became infected in the line of duty. So what happens is the employee then does not have to necessarily prove those two things. It automatically is presumed that those two things are proven, where the employer then has to rebut that and say, well, no, he or she actually got COVID-19 outside of work, but the burden is supposed to obviously fall on the petitioner, the claimant, in situations. So although it didn't automatically make all claims involving COVID-19 compensable, it certainly shifted the burden onto us, which was obviously not helpful for the business environment. So in response, what happened was a lawsuit was filed here in Sangamon County, Illinois, where I'm located here in Springfield, Illinois, on April 22nd, against the emergency rule, saying that the commission didn't necessarily have the appropriate authority to enact such a rule. So that was filed, and actually the Sangamon County Circuit Court judge issued a temporary restraining order on April 23rd, blocking the recently adopted Illinois Work Comp rule. So after that was blocked, the commission recently, as of yesterday, came out and rescinded the emergency rule. So instead of the rule that I believe is still in effect, emergency rule in Missouri, the Illinois Work Comp Commission went ahead and rescinded the rule. They had a unanimous vote on it and basically said, we're not going to have that rule in effect any longer. We're going to look at other ways to help out workers, things like that. So as of now, the burden is still currently on the claimant and the petitioner, which is, how it should be and how the law is written. But, to be determined as to what happens in the future. So moving forward with the impact of COVID-19 on existing claims, you'll see a lot of the same things kind of here in Illinois that Shelley was discussing in Missouri. So, for instance, a lot of doctors' offices have canceled elective surgeries, in-person visits, even physical therapy appointments if your employee is recovering post-operatively. A lot of patients are being forced to do televisits and also at-home physical therapy. They're obviously trusting the employees to work or to do the physical therapy at home. Sometimes, actually, you can even get in certain facilities, the physical therapist will kind of do what's like a FaceTime or a webcam to show the employee how to perform certain exercises and go through it with them. So it's kind of like they're in person at the facility, which is obviously helpful. So as I'm sure you all are, we are also, as well as the doctors' offices, are all adapting to this and trying to find out the best way to move the employees to conclusion of medical treatment and to get them, back to work. So they're also screening patients, just as Shelley mentioned. they ask if you've been diagnosed or if you've been around somebody diagnosed with COVID-19 or traveled recently. If that's the case, their treatment a lot of times is postponed. It's not known when doctors will necessarily return to performing elective surgeries. I have a claim where an employee was scheduled for a surgery. I think it was an amputation of a toe, and that got postponed. It was the day before it got postponed because of all the COVID-19. That was in early March, and we're currently waiting for that to be rescheduled, and we don't have a date for it yet. So it's to be determined when that will happen. So same thing with a lot of the IMEs. Some doctors are performing IMEs. I got one set for June. Another doctor that I was talking to mentioned, I'm not seeing any IME patients at this time, and I'm not sure when I'm going to be able to. So we just have to kind of keep following up with the doctor's offices and trying to figure out when the next appropriate time would be to get them in to be seen. So how does that impact TTD benefits and medical treatment and things like that? So generally speaking, under normal circumstances, obviously this is not a normal circumstance, but unreasonable delays in seeking medical treatment are grounds for suspending TTD benefits. But given the unique circumstances here with COVID-19, it's extremely unlikely, if not impossible, that an arbitrator will allow us to suspend TTD benefits on that basis. This is because it's obviously out of the employee's control and not, going to be considered an unreasonable delay right now. So as Shelley was mentioning, we just have to keep trying to do these televisits, telemedicine, if possible, to try to get them seen and to progress their care. So we will continue to do that, obviously, and to continue monitoring the situation. Unfortunately, the fact that a lot of the employers are slowing on work and things like that, it's also impacting the possibility of transitional light duty. Employers are having a tough time placing and enrolling employees in transitional light duty assignments. So, that's obviously having an impact as well. And TTD benefits are having to be paid out for, several more weeks than they would have normally been. So that's kind of where things stand right now on this impact. In Illinois, the impact on the COVID-19, the impact on Illinois dockets, it has basically, the Illinois Work Comp Commission has canceled all in-person non-emergency hearings from mid-March through at least May 31st. So this is 2.5 months worth of dockets, which is obviously going to cause a backlog at the, in the coming months. So in June, July, August, when hearings and potential arbitration matters are going to be heard, there's definitely going to be some backlog there. They went ahead this month and allowed for telephone docket calls, so you can actually call in, but the cases are basically going to be continued unless there's some reason they shouldn't be. Only emergency hearings, so cases involving emergency treatment, significant financial hardships, et cetera, things like that are going to be heard. But all routine matters are going to be continued for at least another month. And as Shelley was mentioning, it remains to be seen whether they're going to be allowed in June or not. So unfortunately, they're not allowing telephone conferences or video conferencing. The only thing you can call in for are the status calls this month in April or in May. So motions can still be filed and things like that to get cases moving, but that's what we've been doing at MVP. Is I've been filing motions for dismissal, final hearings, things like that. Even if they get canceled, I file them for the next 3 months just to try to keep it on everybody's radar to keep the cases moving along. So that's where things are in that regard. From an employer's perspective, MVP's strategy, kind of in light of the Illinois claims for the COVID-19 pandemic. So from a procedural standpoint, like I said, here as a defense firm, we're just going to continue to try to push case forward by filing motions and requesting hearings, even if they get canceled, like I mentioned. So we're going to keep following up with doctors to see, if they can get them in for an IME, if necessary, things like that. From an employer standpoint, the best thing I think you can do right now is just to continue taking precautions, at work, in the workplace, so you can lessen the likelihood of an employee contracting COVID-19 if they are working at the workplace. That's, social distancing, things like that, so that you can, if you want to fight a COVID-19 case, you can say, well, we put these measures in place to lessen the likelihood that they can practice it at work. That's one thing we do. Getting into it a little bit deeper, their case that they got COVID-19 after, you can certainly try to do a medical canvas of some sort to see if they had any pre-existing conditions. If there was another basis for why, how they got COVID-19, if they had a relative that got COVID-19, anything like that, that's certainly something that we've been looking at as well. But obviously that's, you have to incur the cost of that. And as I mentioned, you're looking at 2 to 3 weeks probably of TTD benefits plus medical benefits. So it may not be worth it in the long run. So that's kind of briefly, I kind of rushed through that, but I wanted to touch on the Illinois aspect of it. But like I mentioned before, a lot of it it mirrors Missouri and vice versa, with the exception of the emergency order getting rescinded by the commission. So at this point, I guess I'll hand it back over to Aaron. And, if you guys have any questions, anything like that about what I talked about or what Shelley talked about, please do ask.
Thank you, AJ, and thank you, everyone. So I do want to give everyone a couple minutes. If you're thinking through the materials, if you have any questions, we'll pause for a moment and let you type those in your chat or message toolbar, and we'll be happy to answer those for you. So we'll give you just a couple minutes here. I want to thank you both again for joining us. As we navigate this, through the next, month or so, it's just interesting to see what all changes come up, with business and everything. It's definitely a lot to keep up with.
Thank you very much for having us. We appreciate the opportunity. And yes, it's definitely an interesting topic to discuss. I really do think it's going to change permanently the way a lot of people do business.
Yes, absolutely. Yeah, thanks again for letting us talk. I mean, I hope that we were able to kind of give a brief overview of this ever-changing kind of thing right now. So yeah, I think it's going to be very interesting to see where things go from here on out.
I agree. We've definitely learned a lot. Well, thank you. I don't see any questions coming in, so that ends our presentation for today. Everybody have a great rest of your day. Next week, we will be covering how to market your business during a pandemic, and with our friend at Harness Digital Marketing, he'll be talking to us. So if you're interested in receiving that information, feel free to reach out to me at hello@HireLevel.com. Thank you again for spending your morning with us, and everyone have a great day.
Thank you.
Thanks.
Thank you.